Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm one of your co-hosts, Rob Van Arnam, and today I'll be joined by my co-host and colleague, Amy Pruett. In our intellectual property practice group here at Williams Mullen, and we're going to be discussing the enactment of legislation in states like North Carolina and Virginia in the wake of name, image, and likeness rules for collegiate athletes, or NIL as it's called. Amy, how are you doing today?
Doing great. I just got back from the Into Leadership Conference where I connected with trademark attorneys and others from all over the world. So it was a great experience. And it seems like NIL legislation is a timely topic with significant changes in the past few years. While there's no federal law yet, a lot of states are doing things that might be instructive.
Yeah, absolutely right. And this is an interesting topic on people's minds. This past July was the first anniversary of lifting the NCAA policy, which of course prevented college athletes from profiting from NIL rights. But as you mentioned, a number of states have already implemented legislation to reinforce the new policies. So maybe it's a good time to start by looking to how states have addressed this topic and maybe to remind our listeners what the policy says and some background of how we got to those state laws.
Absolutely. So NCAA had been reluctant for years to allow athletes to profit from endorsements and name and likeness deals, mainly due to their amateur spirit. And they wanted to maintain that amateur atmosphere among college sports. And there was a lot of student pushback on this for many years. And some students were even breaching these provisions just to benefit from NIL type of contracts and deals. But there were a couple of class action lawsuits back in the 2013, 2014, O'Bannon versus NCAA, and then NCAA versus Alston, both of which were filed in the Northern District of California. And they resulted in decisions in the Ninth Circuit and the Supreme Court, respectively, that basically said the NCAA restrictions violated antitrust regulations. So after that, NCAA agreed to allow student athletes to receive full scholarships for academics and voted to allow student athletes to receive compensation in exchange for the use of their name, likeness, and image. And they adopted an interim NIL policy in June of 2021 that allowed college athletes in all three divisions to have the opportunity to benefit from their name, image, and likeness. So they can engage in NIL activities that are consistent with any state laws that are in place as well, and use a professional service provider for those type of activities. And although they still have a requirement to report any NIL activities to their respective school. As a result, many college athletes have, in the first year since the NIL deals were allowed, gained close to $1 billion. And that is many Division I players who've made some six-figure deals. Many universities have also developed policies and departments to make sure that athletes are still understanding what the NCAA policy says, and any university NIL rules and applicable state NIL laws. They've also formed collectives and booster activities. They monitor those to ensure that they're not providing improper benefits to students and for recruiting for specific schools, as well as making sure that there aren't any improper inducements or extra benefits provided to athletes. So the NCAA recently clarified this policy in October with guidelines on institutional involvement in NIL activity. Can you tell us a little bit more about that, Rob?
Yeah, sure. So recall that the NCAA first implemented the NIL policy in July of 2021. And that same year, in November, they declared some general guidelines. Schools could not use NIL transactions to compensate student athletes or dictate how they could use compensation. In May of 2022, the board released some additional guidance and specifying that coaches and staff may not arrange a meeting between an NIL entity and prospective student athletes. The guidance did not specifically extend the prohibition to involvement with NIL activities for currently enrolled student athletes. So this latest guidance, just approved on October 26th, about a month ago, clarifies how schools can interact and support student athletes for NIL. One facet is that schools are encouraged to provide educational training on topics such as financial literacy and taxes, entrepreneurship, and how to use social media. Schools are specifically allowed to administer a marketplace that matches student athletes with NIL opportunities and arrange space to do that on campus and promote it. Schools are, however, not allowed to communicate with NIL entities regarding specific student athlete requests or demands for compensation. Essentially can't interfere with it or get involved in that way. They can't assist proactively in the implementation of student athletes' activity and provide access to equipment unless the same benefit is generally available to others. And then generally with respect to supporting NIL entities and collectives, again, schools are allowed to assist these entities in raising money for first entities, provide assets and things, tickets, for instance, to NIL entities under scholarship agreements, and things of that nature, facilitate meetings between donors and NIL entities. But schools are not allowed to subscribe to or donate cash to the NIL entity. It can't be a way to fund a source or a pool of money, or it can't provide assets to a donor as an incentive for providing funds to NIL entity. It can't use boosters in a way that it would be prohibited from. And also schools are not allowed to engage in certain negotiating, revenue sharing, compensating activities, including allowing staff members to represent student athletes, entering into contracts, engaging in revenue sharing, or those kinds of things. And any violations that occurred prior to the guidance will be reviewed by the board and pursued only if the infractions are clearly contrary to the interim policy. So with that, new update from the NCAA, but as you know, Amy, there's no federal law, but about 29 states have enacted NIL legislation to allow student athletes to participate all across the country, Arizona to Virginia. Speaking of Virginia, what has Virginia done in light of NIL, and how have things changed for universities and college athletes over the year?
Well, in April of this year, our Governor Youngkin signed a bill that was to be effective in July that set parameters for student athlete compensation and representation that was specifically related to NIL. And it prohibits the institutions from preventing student athletes to benefit or earn compensation from NIL deals. And it also prevents them from saying that the students can't get professional representation from either sports agents or legal representation. And they must continue to allow eligibility for intercollegiate competition and not deny that simply because they're earning NIL compensation. And they may not reduce or revoke any athletic scholarships that are based on an NIL contract. The provisions don't extend to high schoolers, so it's only for college or university level students. And it provides additional guidelines, similar to the updates that were already provided by the NCAA, that students may not license their NIL for drugs, cannabis, alcohol, tobacco, casinos, weapons, or other adult entertainment. So there are certain limitations on what they can do. By way of example, University of Virginia, the Cavaliers partnered with some collectives like Brander Group to provide opportunities for athletes to maximize their name and likeness. And it also provides for fans to support the athletes with co-branded merchandise. So student athletes can join a group licensing program, but they have to also balance that between licensing on their own behalf and any boosters that might be providing improper inducements, so that they would arguably be against the NCAA guidelines. So players still need permission from schools to use any school logos or trademarks or trade dress. This comes up a lot because, of course, when their name and likeness is used, they often want to be filmed or photographed in their uniform. So in order for a sponsor or for an advertiser to be able to use that, they would also need to have a license with the school or university for the use of their logo or trademark. And any deals that they enter can't run contrary to any existing deals that the university might already have with a company. So that's why it's important for players to still seek permission from their school for entering into any NIL contract. And some of the sponsors or advertisers might have to enter direct agreements with the college for certain types of uses. They also can't cross the line of directly providing some type of benefit to the player for playing, which is also known as a pay for play clause, so that there could be an interpretation that they're inducing them to play for the school. Some other examples of some big deals that have been made in Virginia include the Wahoo quarterback, Brennan Armstrong, just signed an NIL deal earlier this summer with McDonald's. And some other collectives have sponsored 28 Virginia Tech players for about $300,000. And there's also some groups that have formed to help students really understand what these policies say so that they can start to make the deals themselves. And there's a pairing of students with mentors for their support and understanding their career and lifetime branding. What's currently happening in North Carolina among student athletes and universities with respect to NIL?
Yeah, Amy, similar to Virginia, a lot of the sort of guidance is the same, but interestingly, so there's no legislation passed in North Carolina, and that may have turned out to be a smart move in the NIL landscape. I know, for instance, Alabama actually repealed its law after noting that it was more restrictive than the NCAA policy. Instead, North Carolina is under an executive order issued by Governor Roy Cooper on July of 2021. A lot of the same guidance and sort of limitations that you outlined for Virginia. Generally, student athletes can earn compensation for name, image, and likeness, provided such compensation is not a direct inducement to participate in sports at a particular institution. They can contract with representatives as long as they comply with certain laws, including the North Carolina Athlete Agent Act, kind of standard thing there. Notably, North Carolina colleges and universities cannot compensate student athletes for NIL. However, they can impose reasonable limitations on the ability to receive compensation. Some of the things you mentioned, they're sort of representatives of the schools, and certainly they need permission for school-based trademarks and logos and IP rights. So there's a lot of opportunities. Same thing as Virginia. It can't be a pay-to-play system, and they have to abide by other school rules. One note sort of interest is not available for international students because of visa restrictions, and that's of course has come under some criticism. And like Virginia and other states, it does not extend to high school students. It's kind of interesting. The average deal is relatively small, of course, when you spread it out among a number of different athletes. Some of the more famous and well-known are, getting lucrative deals. Armando Bacot, who's a UNC star center on the basketball team, has 5 or 6 relatively big deals. And it's reported that UNC, I think for athletes generally, have about $1 million in deals, and they're not required to report it. So that estimate is half of what athletes are getting. And the exchange is going back to what I talked about. The NCAA rules have been set up. For instance, at North Carolina NIL Exchange is an online marketplace that connects Tar Heel students with local, national, and global businesses. And similarly, for like NC State, they have the Pack of Wolves NIL collective that does the same thing, trying to match interest with student athletes so they can benefit from NIL.
Great. Thank you, Rob. Lots of opportunities for student athletes now in light of this NIL deals. So thanks for joining us today to discuss this topic on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.